Good morning, everybody, and thank you for attending this Eviction 101 training this morning. My name is Brandon Beeler. I'm the Housing Law Center Director over at Indiana Legal Services, and we are very excited to have you here today. I'm now honored to introduce Chief Justice of the Indiana Supreme Court, Loretta Rush. Chief Justice Rush began her service on the Indiana Supreme Court in 2012 and was appointed as Chief Justice in 2014. Throughout the past year, COVID-19 has posed many challenges onto the judiciary. Chief Justice Rush took swift action by providing support to all courts throughout the state as they transitioned into emergency procedures, which balanced the health and safety of judicial officers, court staff, and litigants, while also ensuring that operations were able to continue with all parties having fair and equal access to the courts. In June of 2020, Chief Justice Rush commissioned the Landlord-Tenant Task Force, comprising of judicial officers and both tenant and landlord attorneys, to publish a report addressing 3 issues. 1, approaches to prioritizing eviction cases after the moratoria. 2, how to balance the rights of landlords with the needs of tenants. And 3, how to connect all litigants to available resources. In addition to the report, the Landlord-Tenant Task Force developed a number of resources for judges, landlords, and litigants that are available online and widely used across the state. Under Chief Justice Rush's leadership, the Landlord-Tenant Task Force assisted in developing the Landlord and Tenant Settlement Conference Program, which is a free service for both landlords and tenants and can be initiated before an eviction case is even filed to aid the parties in resolving their disputes without judicial intervention. I am personally very appreciative of her leadership and grateful for her presence here this morning to begin our training. And without further ado, Chief Justice Loretta Rush.
Thank you, Brandon. And on behalf of the Indiana Supreme Court, and I see my colleague, Justice Slaughter, is on as well. And thank you. Thank you for going through this training. Thank you for considering to do this pro bono work for such a needy group. When I look at landlord-tenant cases, the numbers are staggering. We have a high number in Indiana. Indianapolis is higher than Los Angeles. Did I read that? Or it's like second to Los Angeles in the number of evictions. So I took a team from the court over about a year and a half ago to eviction court. I said, I'll just pick it. I told Judge Bacon, just pick a day. I don't care what day. Don't set it up. Don't, I'm going to just come. 250 cases set that morning. Not one tenant was represented by an attorney. And it was just the pathos of watching this. I mean, I wanted to say, you've got a couple of defenses, right? Warranty of habitability, but you can't. But I just realized that what's more traumatic than losing your home? And, the conversations, and if any of you have read the book Evicted, I mean, it's just fascinating with regard to what it does to a family. I don't know if anything other than the loss of a child is more traumatic than having your stuff out on the curb and losing your home. So we're seeing that. So what we did was we set up a fast track eviction program for either landlord or tenants. It's free. We got a grant and then we matched it. And it's being very much underutilized. And again, it's, if you don't want to do it, you don't have to do it. It's not mandatory. And if you don't like the result, you don't have to agree to it. But landlords don't have to pay that filing fee. You don't have to go to court. Can you work out something so you don't have that eviction on your record? Because in this age of technology, it's not just going to court, that you have that eviction on your record. And then when you try to get housing later, it becomes just darn near impossible. So there's so many benefits to facilitation at the front end before it happens. It can save the landlord money. It can save the tenant with regard to future housing issues. You can work out a plan. I'd like it. So it's still underutilized. I'm thinking with the moratorium being soon to be ending, I'm hoping it picks up. I'm so encouraged by the sheer numbers of you that are on this call right now, because I think you're going to be a huge part of this. And we're not looking at a law that benefits landlords over tenants. We're looking at just access to legal information to know what your rights are, level the playing field when you go in. With the Innovation Initiative, one of the things we're looking at is online dispute resolution on that, which is different than sort of this fast track that is before. So we're looking at easier, more efficient, more consistent, more predictable ways to work with this population. So the goal today for you attending this training is to just encourage you to engage in the volunteering in the coming months, knowing that there's going to be a lot of these cases. And whether you volunteered in the past or consider this for the first time, there are resources to help you. So you're not going to sort of be an island of your own. There's going to be training. There's going to be frequently asked questions out. And the task force will be making resources available to you. And I will tell you, I did a lot of pro bono when I was a practitioner. You may not remember the name of everybody that you represented on a pro bono basis. They remember yours. I mean, you're sort of the face of justice for them. And I'll be in the grocery store now, even in the ballpark with my kids, and people come up, do you remember when you represented me on X, Y, and Z? So it's a great thing to do. Law students, we have a number of law students that are online right now. What a way to get started. I collected a couple years ago, and I've did it 2 years in a row. I collected all the pro bono hours coming out of our law schools, and it's so encouraging. You are that change that we need, and just to get that heart of doing this. I mean, we all become lawyers because we want to help people. And today we're giving you more tools and more ways to fulfill that goal. So we're, looking at the basic needs of housing and family security, safe and secure, affordable housing. You're contributing to the community. So it's more than just your case. You're contributing to the larger good. So I want to thank you so much for going through this training on behalf of the entire Indiana Supreme Court. You are just the key. You are the key to justice being done in these cases. And when I look at the critical needs we have in our court system right now, access to it is at the top, and equitable access is at the top. So thank you for doing this. The Supreme Court will serve as a resource. If you find something, or you think something, listen, I wish the court would realize this, or, we work with bar leaders, we work with attorneys, we work with the other branches of government, really to effectuate real change. So loretta.rush@courts.in.gov. That's my email. If you have a suggestion, or if you think we're not infallible, what are they thinking? Let us know. But thank you for doing this. And I called and asked, I wanted to help. I said, can I take like 5 hours a month and volunteer? Then our ethics officer, Adrian Myring, told me I was not allowed to as Chief Justice, but I'd be right in there with you. When I look at help on housing and expungements, those are two big areas. And I tell you, the supports are there. We can get you the information. You won't feel like you're a fish out of water in getting that done. So God bless you all for doing this. And thank you very much. Oh, there it is, Joseph O'Connor for everybody. Good. So let me know if we can help you, or if you see something we're doing. And Brandon, I will turn it back over to you. Thank you very much.
Thank you so much, Chief Justice Rush. We really appreciate your words this morning. I'm going to share my screen if I learned how to do this over the past year, I think. All right. All right. Well, good morning again, everyone. Thank you so much for being here. Let me get started. This is the substantive part of the training. I will acknowledge before we get started, there's a lot of information contained in these slides. The way that I design these is to actually be in an outline form. So I believe you all will have access to this PowerPoint, or if not, my contact information is available here. So please email me, and I suggest just putting it into the outline form when you go to print option. And that is hopefully will be a good guide to take with you if you go to do some pro bono tenant advising and tenant landlord tenant courts. So what we're going to talk about today, and kind of some areas just scratch the surface on, but we'll go through the Indiana landlord tenant law and what protections exist and how court procedures are to run. I will really just scratch the surface on federally subsidized housing. That in itself is a huge area, but there are some points to know about it because there are additional tenant protections for those who are in subsidized programs. So I just want to make sure folks are aware of those. Then we're going to get into the number of moratoria for eviction that have emerged over the past year. We'll cover the ones that have expired, and some of them still have protections that linger. And then we will talk about the CDC eviction moratorium, which many of you probably know is in the news again yesterday. So these slides are up to date as of right now. I don't know if anything's happening in the news while I'm not watching it, but as far as I know, this is up to date. Some basic advocacy tips for landlord tenant court. I know small claims court is a different beast for many people. So just some basic tips of how it runs. And finally, some resources on how Indiana has responded to renters during the COVID-19 pandemic. All right, so we're getting started with the Indiana landlord tenant law. And I think to start this off, because I know most folks on the call, or many at least, are not aware how eviction cases work here. In Indiana, eviction is actually a two-step process, or a bifurcated process. The first hearing, which is usually scheduled within 30 days of the landlord filing the notice of claim, is the possession hearing. This is, what we commonly call the eviction hearing. This is when the court determines whether the possession of the property should be with the tenant or with the landlord. So this is the one that most folks or everyone's going to probably be advising on, because this is the determination as to whether the tenant gets to remain in the property. And I just want to also note too, in order to meet the possessions threshold, landlords must prove a material violation of the lease and that they are entitled to possession for that material breach. The second hearing, if the landlord is successful and the case is not dismissed at the possession hearing stage, is the damages hearing. In general, this is scheduled after within 90 days after the date of possession, when the landlord is entitled to possession. The purpose of that hearing is to determine if the parties owe each other any money based on the tenancy. So this is when the landlord will make arguments for how much, for instance, back rent is due, or if the tenant damaged the property beyond wear and tear. And the tenant also has the opportunity to present their arguments about bad conditions or habitability or breaches potentially of the landlord in order to mitigate or minimize their damages. And in some cases, if the conditions were so bad, to actually get a judgment against the landlord for damages at this stage. That's just how it works, and just putting it out there so everyone kind of has an idea, because sometimes you may get confused. The tenants may also be confused as to what hearing they might be there for that day. This is the Landlord Tenant Code. It's contained in Indiana Code section 31, 32, and the rest. So this is how I kind of organize it as my table of contents. Obviously, as you see by the numbers there, this isn't the order the statute goes in, but here's how we'll kind of cover it today. So we'll first start with applicability, and this is the most simple one, but the code defines it as that these statutes apply to rental agreements for dwelling units located in Indiana. So that's helpful, it's broad. Again, the key word there is rental agreement. That's the operative term to prove that it is in fact a tenancy. But the code does indicate who the code or how these what these statutes do not apply to, what types of properties and situations, which are so medical facilities and academic institutions, fraternal or social organizations, hotels and motels, situations where tenancy is dependent on work that the employee does for the landlord, and then agricultural leases are prohibited and do not have the protections that are contained within the Indiana Landlord Tenant Code. As far as general provisions go, this is really my starting point with all landlord tenant cases or all eviction and possession cases, is just to remember that tenants have a protected property right in their rental properties, meaning that they cannot lose possession of their property without due process. And again, the Indiana Code provides the baseline due process that tenants are required to receive, which includes, as we'll get into, notice and other procedural protections. But then when we get into the subsidized housing section of this, you'll see that there are additional protections for those tenants who are especially vulnerable and living in subsidized properties. The first step of due process is notice. Now, again, under the Indiana Code, there are limited notice provisions. You can find them there in section 1 of the code. This is probably the most important one we rely on, which is a lot of tenants, especially low-income tenants, are on verbal or oral leases. And so in that situation, the code does require that landlords notify their tenants that they intend to not continue the tenancy with intervals that are equal to the interval periods. The interval period, that's just a way of saying, and how we look at this and how courts look at this, is when do tenants pay rent? And most tenants pay rent month to month, so that's the example here that you'll find mostly. But we've seen it in other situations. Some tenants pay rent every 2 weeks. Some tenants maybe pay rent every other month. So that's how you kind of determine the interval period, and that also determines when the landlord has to give notice to a tenant that they intend to terminate the tenancy. Indiana Code does not require this to be in writing, but we do encourage that. And again, that's easier to prove in court if it is done in writing by the landlord. If not, then this is common. There'll be situations where the judge is going to have to determine when both parties are testifying that one gave notice and one saying, the tenant saying they didn't. Without any writing, it's really the court's going to have to make a tough decision there. In addition, I don't want to forget that in Indiana, we're a pretty pro-contract state and freedom of contract state, so always look to the lease. Sometimes landlords use leases from other states that have higher protections than we do. So sometimes if they pull those off, and if there's additional protections or provisions or due process rights, the lease governs. So always look to the lease if you have a copy of it. And again, if you're in court or doing a clinic, landlords are required to file the lease along with the notice of claim if there is a written lease. So you can quickly pull that up and sort of scan through to see, to ensure the landlord did follow its own provisions, its own contractual provisions. So now moving on to the tenant obligations. This is pretty simple, and this is just that tenants need to maintain and keep and reasonably use the systems and keep the property in normal condition and not overburden any of these systems. So, you know, they don't have to, you will see that this differs from the landlord's obligations, but they can't actively damage anything in the property, which makes sense. Again, further, they cannot commit waste or damage the rental unit. Tenants are responsible for ensuring that smoke detectors are working. That's a tenant obligation. And prior to vacating, only ordinary wear and tear is permitted. So that's sort of the standard. And frankly, there's not much case law on that, but that's again another subjective standard, but just to know. And again, landlords do have a private cause of action against the tenant if they fail to maintain the unit or damage the unit in some way. Now, moving on to the landlord obligations, this is where we'll find Indiana's warranty of habitability, which is contained in the Indiana Code. The code states that landlords must deliver the rental unit in safe, clean, and habitable condition, comply with housing and health codes, make reasonable efforts to keep common areas clean. The code also specifically requires landlords to provide and maintain the the electric system, plumbing, sanitary, air conditioning, and heating. Again, the hot and cold water to the unit. And then I know this last one's a weird way to phrase it, but appliances, well, it should be supplied, not supple, and I apologize for the typo, but appliances supplied as inducement to the rental agreement. So this really just means that any appliance, we view this in the courts that we've done this with and have viewed this as any appliance that comes with the unit, a refrigerator, an electric range, something like that. You know, that we consider that inducement in the sense that a tenant could easily say, well, no, I wouldn't have rented a unit without a refrigerator. I would have looked somewhere else. So that's a pretty low threshold, but just knowing that the landlord is obligated to maintain the appliances as well. So if a landlord fails to abide by the warranty of habitability, the code provides a private cause of action for the tenants to enforce, but you need to know that there are prerequisites before a tenant can file. So there are some due process protections here for landlords. The first is the tenant must give landlord notice of the defect. Code does not require it to be in writing, but again, for evidentiary purposes, it's certainly recommended and advised that it is in writing. This can be a text message or an email. It doesn't have to be a formal letter by any means. The landlord must have been given a reasonable time to cure. You know, this is a subjective standard, and it really is going to be based on the circumstances what reasonableness is. Just a note, the tenant cannot prevent the landlord from fixing the issue. That would reverse liability in that situation. And then finally, the landlord had failed or refused to repair the condition within that reasonable time. So once those three requirements have been met, then tenants can bring a private right of action or cause of action for damages, or to compel the landlord to make the repairs. A really important note that probably should be the first part of this slide is just to note that tenants in Indiana cannot withhold rent due to bad conditions. In many other states, that's not the case. And a lot of tenants will talk to their family members or friends who say, well, how come I have to pay rent because, you know, the landlord's not keeping up their end of the bargain? Well, at this point in Indiana, and again, how we have to advise our tenants is tenants can be subject for a non-payment eviction if they refuse to pay rent, even if the conditions are bad. So sort of a baseline thing to always remember when advising tenants is that they do always have to continue to pay rent. So now we're going to talk about the emergency possessory order. This is sort of commonly called, you know, emergency eviction, and you know, it's been kind of thrown around a lot the past year. But I want to kind of be very clear about what it is and what it isn't. So emergency possessory actions, or orders, I should say, are actions that can be used by landlords and tenants. And as a quick note, I have actually called some courts before, not here in Marion County, but in some counties near us, that did not know that tenants could file emergency possessory orders. But they can. And so that is the case, and just pull out the code and you can show that if you need to. So for landlords can only bring an emergency eviction case or an emergency possession case if the tenant has committed or threatens to commit waste to the rental unit. It's waste, it's damage, that's it. There is no other reason that a landlord can bring an emergency possessory action. I have a note on this slide because I was privy to a few questions from folks who registered, who've said that they've been in situations in court where the landlord brought it an emergency possession case for not waste, for another reason. I've been in that situation too. I've been there where landlords have brought it for saying the tenants have threatened management, or tenants are just being loud and angry or whatever. That is not cause for emergency possession. So if that is the case and the landlord somehow managed to get an emergency possession or possessory order, that would be something to certainly advise the tenants to continue working or to call legal aid. We'd probably file maybe a motion to correct error depending on the circumstances and or an appeal, because this is a pretty clear-cut statutory. There's no catch-all provision here. This is the only reason landlords can bring emergency possession cases. So tenants have two options for when they can bring emergency possession cases. That is if the landlord has violated the warranty of habitability, but I also want to note it needs to be an emergency situation. So, the heat going out in the middle of the summer is probably not an emergency unless there are some other circumstances or facts. But otherwise, the heat, the air conditioning going off in the middle of summer, that could be an emergency if the landlord again has had time to repair and has failed. The other reason, and probably the most common reason that we advise our clients to bring possession order claims, is when the landlord prevents or prohibits access to the unit. So that can be a change of locks, shutting off the utilities, taking off doors and windows, anything like that that makes the unit, that prevents access or interrupts access to the unit. Tenants can bring emergency action claims. They can be filed in small claims court, and this is one of the few exceptions where small claims courts can actually enter injunctive and can order injunctive relief in addition to damages. So what needs to be in the statute? In one of the petitions. The statute's pretty clear. The petition must include first the specific allegation of the default. So go back to your reasonings, the code of why you can bring one of those, and name the specific allegation and how it fits into that those categories. The nature and the specific and immediate injury, loss, or damage. And the petition must be verified, which simply means it must be signed by the tenant. Once a petition is filed by statute, the court must set a hearing within 3 days. And I just want to, again, if I haven't beaten this drum enough, the landlord must allege waste by the tenant. That is the only reason. Again, this is a common issue. I've seen personally a lot. I know attorneys in our agency have as well. I just want to kind of also note, going back to, again, that guiding principle I run by of tenants have a protected property interest and are entitled to due process. A hearing set within 3 days is a very significant time, a very short period for a tenant to, first of all, even know that they have to go to court, and let alone prepare evidence if it's being brought against them. So that is really the reasoning behind why it's so limited as to why a landlord can bring up an emergency possession case, because it seriously limits the tenant's due process rights. So I just wanted to, and the due process scheme, frankly. Finally, I want to talk about the victims of crime provision in the landlord-tenant law. There are some heightened protections and options for tenants who are victims of certain crimes. We most commonly see this with victims of domestic violence, but the statute does include other crimes, such as crimes involving dating violence, stalking, and things like that. So you can look to the code to see the full list of crimes that are covered under this. The first protection tenants that are victims of crime have are a change of locks. So if the victim and the abuser do not live together, the landlord has 48 hours within which to change the locks. If the victim and the abuser do live together, the landlord has 24 hours. Now, in order to get a lock change, the victim must do two things. First, must make a written request to the landlord, and must also provide a copy of a civil order of protection or the criminal no contact order. One note on this, and I actually bring this up because landlords have actually called me asking me what to do. Under the code, landlords are not permitted to allow the perpetrator to return to the unit, even if the perpetrator is on the lease, or to collect belongings, even if the victim is not there, unless there is a court order that allows the perpetrator to be there. So unless there's a court order, the landlord must prohibit the perpetrator from being on the property. So victims do have to reimburse the owners for the cost of the lock change, except If the owner does not do it within the period, the time periods above, then the victim can change the locks, and then the owner must reimburse the tenant. So again, the 48-hour and the 24-hour clocks start after the victim provides these two documents to his, her, or their landlord. The second protection for victims of crime is that it allows tenants to terminate their lease early without penalty. In order to do that, the victim must supply three things to the landlord. First, a 30-day written notice to let them know that to let the landlord know that the victim is intending to vacate the property, which includes, again, a copy of the protective order or the no contact order. And there also needs to be a copy of the safety plan provided to the landlord. I will say I am not familiar that much with safety plans. In Indiana, we have really, really great domestic violence shelters and programs and agencies that always take care of these for us. So I put them on there just so you know what the statutory requirements are, but generally those are always taken care of us by our partners at these DV shelters. So I just want to let you know that if you do talk with a tenant who discloses to you that they are a victim of crime or domestic violence and they have not already consulted with the DV shelter to get a safety plan, if they would like to terminate the lease early, they will need to do that. So that's just a little tip there for that. And again, they're usually taken care of. And to note too, there is a prorated rent. The tenant's only liable for the rent for the period they live there. You know, life happens. It typically doesn't happen at the first or the end of the month. It's usually at some odd day. So the tenant will only be liable for a prorated amount of rent for the time they remain. That's Indiana. The only other note, and this is from the questions I received or I saw beforehand, someone asked about the eviction expungement. Well, in Indiana, we don't have eviction expungement. There was a bill, I think, that floated to the legislature earlier this session that didn't make it through at this point, but the only I have heard of, and I have actually gotten one eviction record ever sealed. It was sort of an odd situation and actually involved a victim of domestic violence where the attorney put on when filing the claim, put notes from my client's interactions with her counselor about the domestic violence. So it was a bit of a rare and extreme circumstance where I was able to get that sealed. But what we are looking at from a practical sense, and I don't think anyone's gonna have to worry about this during the tenant clinics you're doing, but just for knowledge, you know, I would look to the rules on access to court, Indiana rules on access to court records. Rule 6 provides a mechanism for when records can be sealed. So in circumstances that are maybe more egregious, we're looking into that, or if it's a wrong filing or something. And that's really the only option or avenue I know at this point, but it's really something we're looking into. So that's just a little note on whether we have eviction expungement here. All right, so now we're going to move into federally subsidized housing, and I just want to be very clear, this is really just scratching the surface. Again, this is, I know, very complicated, but the primary programs we're going to talk about today is certainly not all of them, but these are the main ones we see in our office: is the public housing program, the Section 8 housing choice voucher program, project-based Section 8, and the low-income housing tax credit program, or Section 42, or the acronym LIHTC. And again, we're going to give some basic notes on these. The commonality between these federally subsidized programs is that all of them do have heightened tenant protections, additional notice and due process protections, and all the programs have a good cause element that must be shown prior to terminating a tenancy or not renewing a lease. I want to start off with a practical tip, and I was debating whether to do a live tutorial, but this is a kind of an old database, so it goes a little bit slow and may have been wonky to do this morning. So I want to alert everyone, and you'll see the website at the bottom about the National Housing Preservation Database. When I get an intake, the first thing I do is pull this up. Many tenants who are in subsidized programs, unless they're on a voucher, many of them don't know which program they're in or that they have additional protections. So you can join, and it's a free, you do have to sign up and give an email address and password and all that, but it's free. The National Housing Preservation Database, which keeps pretty good records. It's not perfect, but pretty good records of federally subsidized programs throughout the country. So this is the first page once you log in. What you'll click is the data access, so full data access, that blue button right there. This will take you here. You'll see it starts with an alphabetical list. We're in Alabama. That doesn't really help us, but this is where it starts off. And you'll see, and again, I did a little tutorial here. After you get to this page, when I want to search or hone in on a property, everyone does this differently, so feel free to fool around with it. I don't know if my method is the best method, to be frank, but you'll see there's zip codes, states, names. I usually start off first by typing in the city I'm in. Let that load, it'll take a second or two, and then I'll type in the property name. If that doesn't work, I'll look up the address, and the address is usually the leasing office address, which may differ from your tenant's address. But here I just did a simple one that I knew was a subsidized property here in Indianapolis. So I typed in Georgetown, and the one I was looking for here was Georgetown Apartments on Bunker Hill Drive. What you want to do if you want to see what kind of subsidy is there, at the very, very far right, you see that details. You'll click on that details and it'll take you to a fact page about the Georgetown Apartments. So here you'll look down at the bottom and you'll see I'm in the active subsidies. And here we can see it's actually there, it's mixed income, meaning that there's two different properties, or there's two different subsidies it looks like at stake here. We have Section 8, and there's your LIHTC or Low Income Housing Tax Credit Program. I'm not going to get into RAD, that's a whole other thing, but if you see RAD come up as the subsidy subname, that means it's project-based Section 8. That's really all you need to know about RAD for the purposes of this presentation. But so here we go. So now we know that we're talking to a tenant who told us they live at the Georgetown. They are probably looking at their lease, either if they have a lease with like IHA Partners in Housing, it's going to be project-based Section 8. If they have a lease with Insight Development Corp., it's LIHTC. So that's a kind of a way to look and quickly know whether or not your tenant is in a subsidized program. And again, that's the website sign up, and I'll leave my email address and help anyone. That was just a quick tutorial of that. So quickly on the public housing program. This is a HUD program that offers the most protections to tenants. How you can quickly identify it is it's the Public Housing Authority. So whatever community you're in, here we have the Indianapolis Housing Agency, but there's the Vanderburgh Housing Authority and all these other ones throughout the state. They are the landlord of the management company, and generally the tenant will pay their rent to the housing authority. That's kind of the quick way to see if it possibly or probably is public housing. In public housing, leases automatically renew. There is a requirement that PHAs have to annually recertify tenants, but if they don't do that, the lease automatically renews even without the PHA's recertification. There is a good cause requirement to not evict or renew the lease. There are specific reasons that are contained in which are the normal, again, material lease violations for why a tenant can be evicted from public housing. But there is a written notice requirement that the PHA must provide to the tenant prior to initiating the eviction case. So when you're looking at these and you have a public housing case, and we'll get into what needs to be in the notice, if the landlord has jumped the gun and filed prior to the expiration of the written notice, that should be an automatic cause for dismissal. There's federal case law supporting that as well. An additional, public housing is the only program that actually has an internal administrative grievance hearing that again needs to be completed prior to filing, but it also must be requested by the tenant. To give you, if you're going to look at a notice, because it should be part of any filing for public housing, this is what the notice must contain. So obviously the grounds must let the tenant know that the tenant has a right to respond and examine the PHA documents, which essentially means the tenant has a right to view his, her, or their file, and the right to request a grievance hearing. It must specifically say that they have the right to the grievance hearing and give them a timeline on when they must respond to it. So that must be in the notice. When I say unless an exception applies, I'm not going to get into it too much today, but there is one exception in the public housing program that came out in the 90s, but is still around. It's called the one strike you're out policy. This is really limited for gang or drug crime. This is back in the 90s. It's under the Clinton administration when drug and gang violence was a big hot topic. And so that's why they put this in there. If it is a one strike eviction, then the tenant is not entitled to the grievance procedure and the landlord can file for immediate eviction. Here's your timing. It's non-payment, they have to give them a 14-day notice prior to filing. Criminal activity other than drug or gang violence is reasonable time. And any other cause, it's 30 days. And there's how you serve. And these are just, again, things to kind of check off as you're reviewing documents and seeing if there's any procedural defenses to tenants in public housing. So moving on to the Section 8 Housing Choice Voucher Program. This does offer higher protections than private landlord-tenant, but not quite as high as the public housing program. How this program works is the voucher, which is the subsidy, is provided by the housing authority and given to the landlord to subsidize or offset the tenant's, the market rent for the unit. Tenant pays their portion of the rent directly to the management company, not to the PHA. Leases, these are private leases. They do not automatically renew, but look to the lease to see what their requirements are for that. There is a good cause requirement to not evict or not renew, which is again heightened and higher than Indiana's section than what Indiana law requires. Additional written notice is also required prior to evicting. Again, no grievance procedure. But I want to make a note here that the voucher and the possession of the unit are actually two different property interests, protected property interests held by the tenant. So the voucher termination is a separate hearing that happens through the PHA. Just because a tenant is evicted, or if a tenant is evicted from a housing choice voucher program, that tenant still has an active voucher. The PHA has to take steps in order to terminate that. So just to know that's two steps, and you should encourage your tenants, if they've heard from the PHA, or if they've not heard from the PHA, that they probably will, and that they need to respond to request their termination hearing if the PHA is going to move forward with to terminate the voucher. Again, here's just your notice what the notice requirement must be in the written notice provided to tenants in the Section 8 Housing Choice Voucher programs. And now we'll move on to project-based Section 8. Again, higher protections. The difference between this Section 8 program is that just the easiest way to think about it is that this is unit-based. The unit itself has been deemed a Section 8 unit. So once the tenant moves out, the tenant does not take that subsidy with them like they do with the voucher program. So that's just a way to think about how it works and the mechanics of it. Again, leases don't automatically renew, but I added this note here because originally they did, but in the 90s, I think late 90s, 99, I think was when HUD or Congress changed the rule, and they don't automatically renew anymore. However, there are lots of landlords throughout the state here that have been running project-based Section 8 programs for decades. So some of them use the old leases. Again, the lease governs. If you see that there is an automatic renewal provision, that is valid. Again, there's a good cause requirement, and there is written notice prior to filing for eviction. But while there's no grievance procedure in the project-based Section 8 program, the landlords must offer the tenant an opportunity to discuss the termination. Usually landlords will offer about 10 days for the tenant to respond and meet with them to discuss it, but that must be offered to the tenant again prior to filing, and failure to do so should be cause for dismissal. Moving on to the final program we'll talk about is the LIHTC, or Low Income Housing Tax Credit Program, or the Section 42 program. This is the program that looks the most like private landlord tenant. And again, I think I've said this, but a lot of tenants don't know they're in this. They just know they're in quote unquote affordable housing, is what they'll say, is what tenants will say. But, again, LIHTC has additional protections. Just as a note of something to know is that the LIHTC is actually an IRS program. This is not a program operated through HUD. Again, the landlord just pays tenants to the management company. And there is a good cause requirement. The reason I have such an excited exclamation point with that is when I first started doing these presentations and started this work, it was really hard to find that in statute or in support, but I'll show you on the next few slides where you can point to that, because some judges may not know that either. There's no written notice requirement. Again, it follows Indiana law, and there's no grievance procedure. So here, I'm not going to read these to you, but IHCDA, or the Indiana Housing and Community Development Authority, is who administers the LIHTC program throughout the state. This is from their guidebook. Again, this is meant to be used in outline form. So there's the direct quote from their guidebook that good cause is required prior to terminating the tenancy or not renewing the lease. Here are their examples of what good cause is. While written notice is not required, IHCDA does advise it in their guidebook, and then I continue to just a note of how to write those notices. In addition, the IRS guide to Section 42 also includes language about how good cause is required. So I just again put that there for your reference. And they're very similar to what the IHCDA's guide is, but these are their examples of things that can be good cause to evict or not renew a lease. All right, now we're moving into what's happened over the past year, which was a lot. So I'll do my best to sort of categorize and summarize the moratoria that have happened throughout COVID-19 and the updates we even got as of yesterday. this is all you need to know about the Indiana eviction moratorium. This was the most sweeping moratorium that prevented all eviction for all reasons except for emergency possession orders, which we know now is only if the tenant was committing or threatening to commit waste was the only reason. The landlord between March 19th and August 14th of last year were the only reasons that a landlord could have brought an eviction case. Tenants were still obligated to pay rent during that time. And that's really all you need to know. So the initial federal responses to COVID-19 was, the first one was on March 18th, when HUD issued an eviction moratorium for FHA insured mortgage properties. And I'll talk about that a little more in a minute. But then the big first one that came out was the CARES Act, which came out and was, well, I guess, was passed and signed on March 27th of last year, which did implement a federal eviction moratorium to certain covered properties. And it also included heightened due process and notice provisions. I'm not going to cover all these. This is, again, just for completeness and hopefully for your aid if you're advising tenants. Here's all the HUD programs. Obviously, all the ones we just talked about are on there. Department of Ag programs were on there. And as you'll see from the Treasury, the LIHTC program is on there. And rural housing is also on there. So that's the complete list of protected or covered properties under the CARES Act eviction moratorium. The CARES Act moratorium lasted from March 27th through July 25th of last year. It restricted landlords from filing new cases for the limited cause of non-payment of rent. It prohibited also charging late fees and penalties that were based on non-payment of rent. In addition, the CARES Act had a heightened notice requirement that required landlords, and again, as you all just saw, these programs, some of them already had 30-day notice requirements, but in case, they just made it clear across the board that there is a 30-day notice requirement that could not be given until after July 25th, because that's when the end of the moratorium, the CARES Act moratorium ended, and it only applied non-payment cases. And again, there's a due process violation if the landlord did not do this 30-day notice. And just to recall, good cause is still required. The continued applicability for our purposes today of the CARES Act moratorium is just to look, if you have a tenant, and many tenants that we're seeing are certainly over a year behind in rent. But if the landlord is attempting to, if the tenant is in a covered property and the landlord is attempting to add fees for this period, the March 27th to July 25th, the CARES Act avoids those fees, so those should be taken out of a ledger. And in addition, that 30-day notice is still applicable. We are arguing that even if it's a covered property and the landlord's going to go for non-payment of rent, the 30-day notice is still required for tenants in these federally subsidized properties. I'm not going to talk much about this FHA insured mortgage property. It's a bit confusing, and frankly, I cannot say for sure, but at this point, it has not been updated. It still looks like it's going to expire next week. This morning, I got some other notices of extensions through HUD, so maybe they're coming out with it today. But as of when I prepared, or the last second I could put any notes on this presentation, it was not extended. And essentially, if it's a property, which are mostly apartment complexes that have FHA insured mortgages, that their tenants, landlords are prevented from evicting those tenants. There's a website. Again, you can take it down, or you'll have access to these slides. This is what I use to search for properties. This is even less intuitive, and it's a little slower of a database than the preservation database I showed you earlier, but that is what you can look up. And if the property is on that list, then I suggest having the tenant, or advising that the tenant bring that forward to the judge and have the landlord prove either it's not or it's a mistake to be listed. And that's really all on that one. All right, now to the big CDC eviction moratorium, which we just learned yesterday will be extended for another 30 days, but it will be the final extension. So on September 1st is when the CDC surprised us all and announced that they were going to be issuing it. It took effect on September 4th. It declared a national moratorium on residential evictions for non-payment of rent for all leases. So it's more than just covered properties. This also applies to private landlord-tenant leases as well. And again, as of 6/25, as of today, it's been extended through July 31st. And again, the CDC, even in its own order, the Federal Register has made it very clear this will be the last extension of the CDC eviction moratorium. I provided a few definitions just to sort of help start out what housing is covered. Again, it's any residential property. They don't define landlord or owner. Again, you can read specifically what the definition for residential property is here. that's similar to Indiana's. But just to note, the CDC eviction moratorium does explicitly exclude hotels, motels, or other transient housing or seasonal housing. So those tenants, or I guess they aren't tenants, but individuals living in hotels or motels, even extended stay ones at this point, are not entitled to protection under the CDC moratorium. You know, basically it prevents two types of evictions. First, again, for covered persons, which we'll go through on the next slide. And then there are 5 categories that are not precluded. So these are 5 areas where landlords can still evict tenants. So it's criminal activity or threatening health and safety. As examples, I would really hone in on this last one, which some folks are saying is a catch-all. I'm not really finding it as a catch-all, but one of the biggest questions we get, and unfortunately I'm not going to have an answer for you today, I don't think any of us are, as to whether holdovers or whether leases had expired. Some folks are using that as a reason. But I don't think that's a violation of a contractual obligation, but that's, again, my view, and there's lots of different views on this, and frankly, we don't have much to go on with that. So who is a covered person? A covered person under the CDC order is, first of all, a tenant who provides a declaration to their landlord. That's it. That's all that's required for a tenant to be covered under the CDC eviction moratorium. This is a copy of what the CDC's tenant declaration form looks like. These are widely available. They're on our website. They're obviously on the CDC's website. They're on the Supreme Court's website. I think most courts have them on their website. So these are pretty common and easy to find. And this is really what they do. The tenant just needs to be able to check something in column A, something in column B, verify the back and sign it, submit it to their landlord, and they should be covered through July 31st and not being able to be evicted for non-payment of rent. So what effect, again, this is a little bit more in the weeds and we'll probably get into when you're doing advice clinics, but I think the way I read the order is that all steps are prevented. But obviously eviction cases are still being filed, and I'm not bringing claims for that. But just again, this is how I'm reading the statute or reading the order, and this is what some of the other national advocates how their view of this is as well. I do want to make a note on landlord liability because this, we've had a lot of issues with enforcement of the CDC eviction moratorium. A lot of landlords going forward and not telling tenants this exists. Courts not telling tenants this exists. Many tenants in Indiana, I mean, I've witnessed it, have been evicted for non-payment of rent who likely qualify for CDC protection, but were never notified of the fact this moratorium is even in place. So really, just as a kind of call to action, everyone here today, some of your job may simply be telling tenants that these protections exist. I've spent the past couple of weeks in a few doing some on-the-spot clinics and testing it out here in Marion County, and I will say every time I did a court session, at least half of the tenants did not know they qualified for this. They didn't know about rental assistance and all these other things. So just because we hear all about them, most low-income clients, and I shouldn't say most, but many have not heard about these protections. So in order to kind of bulk this up, originally, the first thing, the CDC order did impose a criminal penalty for landlords who didn't comply with the order. They specifically gave the DOJ the authority to enforce. I've sort of spoken with them, and it's no one should be surprised. The DOJ has a lot of other things to do there. I think they would only look for really egregious violations, but that's just that's part of the order, so everyone knows. So the Consumer Financial Protection Bureau actually recently, the beginning of May, published an interim rule that amended the Fair Debt Credit Reporting Act. And what it did, and there's the site for it, so you can look it up. It actually requires landlords to provide written notice to tenants of their protections under the CDC order, and also to clarify any misrepresentations. I can just frankly say this isn't happening. Again, I'm sure some landlords are. I don't want to paint a broad brush here, but I have not seen this. And really, I just recently had a long conversation with another colleague at another agency about this, and we're looking into maybe some more enforcement of this. But this is, again, a Fair Debt Credit Reporting Act violation for landlords who do not inform their tenants of the CDC moratorium in writing. And if you need some more support from that, there's a letter, or I should say a joint statement from the Federal Trade Commission chief, as well as the Consumer Financial Protection Bureau chief, that I believe is dated March 29th, that also shows support for this rule and landlord compliance. Well, this is the last thing I'm going to talk about from yesterday. It was a pretty busy day, but the DOJ also issued this letter that provided some guidance for how to do some eviction diversion. There's really not much more to know about this. This is more just to kind of keep everyone up on the news while you're here today and in your eviction mindset. So, here's some suggestions that the DOJ put out then they address this, as you can see, to Chief Justices of state Supreme Courts, as well as state court administrators. They've suggested requiring landlords to apply for rental assistance before filing, extend time in pending cases so that tenants can get access to resources, and also give the state time to distribute the resources, modify summonses so tenants to actually inform tenants about their resources before they get to court. And we've already done this one today, so Indiana's ahead of it, is just to partner with community-based organizations and legal aid. So there we go, Indiana's ahead. All right, now moving on to basic tenant advocacy. And this, again, is just going to really just kind of give a scratch the surface on what we've learned today and what we've kind of talked about. So the first thing I want to just raise are these procedural defenses. I know I spent a lot of time on due process and notice and all these things that I'm sure are bringing you back to your contracts classes. So I apologize for that, but we're going to kind of get through a few more contract defenses. And first and foremost, deficient notice should be a defense to eviction. It's a due process violation in my view, and the courts have upheld that. So look at the content of the notices and compare them to what, especially if they're in federally subsidized programs, compare them to what is required to be in those notices. Here are some examples I put on there. So, for instance, if a notice for a public housing tenant does not include or offer the grievance hearing, that's a violation. Again, they've jumped the PHA has jumped the gun. They've not tried to use the protections that tenants have to avoid a court filing by going through a grievance. So again, that should be a dismissal and sent back to the PHA in order to offer the tenant the grievance and allow the tenant that opportunity. Timing requirements, the service, all these kind of things. And again, I'll just make another little note about that the lease governs, and when landlords use leases from other states and have more protections, if they're in the lease, they count and they are applicable here. So some common defenses that you can use to avoid an eviction or to either get a dismissal or to get a judgment in favor of the tenant and not the landlord is when there's retaliation. So if the tenant has done a protected activity, this is most commonly done when tenants call health departments because the landlord or because of bad conditions in their unit, and the landlord files for eviction. If you can show and make a good argument, or the tenant can show and make a good case that it was retaliatory for doing that protected activity, that should be a dismissal and automatic defense to eviction. Discrimination, which is governed under the Fair Housing Act. The inquiry here is essentially, is the tenant being evicted, or is the adverse action taken by the landlord based on the tenant's protected class status? Waiver and estoppel. This is pretty common. We have it sometimes where even though the lease may say that rent is due on the 1st, but it's late by the 5th. But if you have a situation where the tenant has been paying on, let's say, the 15th every month for 6 or 7 months, and then the landlord suddenly brings a case for non-payment or a lease violation because the tenant's always late, if the landlord has accepted that rent, the contract's been modified, and under contract law, common contract law, the landlord should be stopped from being able to make that argument. Additionally, if the landlord accepts rent after they've declared the breach, this is looking again to the notice of claim. When was it filed? When did the landlord say that the tenancy should have expired due to the breach? And if the landlord accepted any benefit under that contract, then that should again be a dismissal of the claim. And finally, if the landlord continues to accept hub subsidies, in other words, meaning that if it's a Section 8 voucher holder and the tenant and the landlord continues to take the subsidy payments during that time, that also there's some case law supporting that should also be a dismissal of the eviction claim. If the violation is cured, of course, that should also be an absolute defense. And then domestic violence, especially for federally subsidized programs, the Violence Against Women Act has special protections, especially and most commonly used to bifurcate the lease to remove the abuser from the lease if that is something the tenant or victim would want. And also going back and remembering our victims of crime protections under Indiana law. So non-payment of rent, this is the most common one. And again, if you're dealing with CDC right now, we don't directly have to deal with it, but you may want to advise your tenants going forward. There are very few defenses, but here are some that are permitted or that have been allowed. Essentially, it's, if the rent's been calculated wrong, if a tenant had a reduction of income and maybe failed to tell the housing authority that they needed to reassess their amount of rent, housing authorities are very liberally allowed to go back and retroactively apply increases of the subsidy. If the tenant's overpaid by law, the overpayment has to be applied to the next few months, to the next month's rent. Late fees or other charges, those should be separate from the base rent. And frankly, again, it happens, but I argue, and I think there's a good basis of argument, that a tenant should not be evicted for just being late on late fees. If they can cover base rent, we can worry about fees another way, or get to a payment plan, or again, landlord can go after for damages later on. De minimis non-payment, again, this is sort of a subjective contract standard, but how short was the tenant? Was the tenant only $10 short? I mean, should the tenant really be evicted for that? These are just, again, some examples. And again, the final one, which is unfortunately becoming more common, and we are starting to apply this to landlords who refuse to accept rental assistance, that if the landlord refuses to make themselves whole, then the landlord, in our view, is stopped from bringing an eviction claim, and frankly has waived the rent for those months where the tenant maybe found resources to pay. There are a few, and I'm not going to really get into these. Again, I'm sure I've driven you all crazy back from your contract law days. So these are just a few other contract defenses you can look into and see if these apply. Again, this is going to be more difficult to explain to a pro se tenant how to argue these. So just to put that out there. Of course, unconscionability. All right. So constructive eviction is something folks may have heard of here too. This is a situation where the landlord fails to do something that the landlord is legally required to do that renders the property uninhabitable. It doesn't actually require a warranty of habitability violation, but it usually is. Tenants can vacate the properties in these situations and assert damages against the landlord. I want to also note this can be used as a defense as well in eviction cases. This is what the tenant must show, that these uninhabitable conditions interfered with the property, and based on the landlord's actions or inactions, the tenant had to vacate. To bring a constructive eviction defense or claim, the tenant must vacate the unit. Now, that does not mean that the tenant leaves and lives with their friends. The tenant must move out of the property entirely in order to bring the constructive eviction defense or claim. There's also the violation of the covenant of quiet enjoyment under common law. So again, this is just that it's undisturbed right to enjoy the property, and there's actually liability by the landlord or third parties for these conditions. We've talked a bit about sub-help eviction earlier, but it's again, to make it very clear, it's prohibited here in Indiana. This means landlords cannot lock tenants out of their units without a court order, or otherwise, turn off utilities or electricity or anything like that to try to force a tenant to leave. So that's essentially what it is, and basically the relief here is the emergency possessory order. If a tenant tells you they've been locked out of their unit, they should file or move for an emergency possessory order action to regain access by court order, even small claims court. So I added a few more slides of the issues we are seeing currently here on this. The first is cases being filed against tenants who have active leases where the property is sold during the tenancy. It's a booming housing market, as many probably know, so there are lots of folks selling their properties. So what do we do here if a tenant shows you a lease and the new owner is trying to evict them? Well, thank you. I don't have my intern's on, but thank you to my intern, Connor, because I had him do this research project very quickly. Here's our basis that the leases do run with the land. The leases, so even with the new owner, that unless there's been some other agreement made with the tenant, the lease follows with the new owner of the property, and the rights of the lease are there. And final note of working with tenants, and again, I'm certainly not a social worker, and I do not, I'm still learning myself how to deal best with tenants who are in crisis, but as sure you all know, even just from watching the news, tenants are in crisis. Really, some of your job, really, if you're going to do these tenants or these clinics, is really just in organizing them. I mean, I've talked with judges and worked with them, and they've really just been appreciative of when we can help to focus the tenants on the issues that they're there for in the court today, which is going to, or for that day, which is going to be possession of the unit, not these other things. But be mindful, and if there's other resources or there's other things and that the tenant are dealing with that may that may be aided by legal aid or by a lawyer assisting, obviously you can reach out to the pro bono groups or advise the tenant to call legal aid and see if we can provide some advice or possibly an attorney to help the tenant. But really just keeping the tenant focused sometimes is the biggest thing to do. Again, I think that when Scott talks later, we're working on some materials for everyone to use. So maybe getting some sheets and checklists and giving the tenant some action steps. So sometimes it may really be your advice is telling the tenant to ask for a continuance and giving the tenant a list of items they need to bring with them to the court next week. So, proof of payment. So if they have money order receipts or things like that to show they've paid rent or anything else, or bring witnesses if it's about a criminal activity or a tenant dispute. And then again, I would just advise, because this is usually what I do before I do these tenant clinics, is I just open a browser and put up all these resources just to have ready to send. So just have your list of resources ready too, because again, many tenants do not know what are available to them and just need to be connected or given information on how to get those resources. So finally today, we're going to conclude with what Indiana's response to COVID-19 is. And I'm not going to get into a lot of them because we do fortunately have a representative today from IHCDA who's operating the statewide rental assistance program and can provide you a lot more information on that. So that's all I'm going to do, is show you the website. And I'll let IHCDA, I'll let Ms. Phillips take that over and explain that to you more. Just so everyone knows, some, and many of you probably do know, some local governments and counties are operating their own rental assistance programs. If your county is running one, then you are not qualified, or those tenants are not eligible to get the statewide program from IHCDA, but should look to their county programs, which I believe are mostly online. We may have a packet. If we don't, please feel free to email me. I have information on all these programs and I'm more than happy to share them if you have trouble accessing them. But these are the counties here in Indiana that are running their own ERA programs. And just also kind of note, I think this will probably be covered, but for ERA is being administered through the Department of Treasury, which has given very, very broad discretion to the states on how to distribute this and what it can be used for. It can be used for back rent. It can be used for rent going forward. It can be used for fees. It can be used for utilities. It's a really long list of things that folks can use it for. And the Treasury allows for these funds to be used up for 15 months of assistance for tenants. There is a utility assistance program, again, run through IHCDA. There's your website for it too. Again, you'll see this when you get a copy of the slides. Online tenant declarations. I showed you a copy of those earlier, but a really easy one to use. And I know this is Indianapolis focused, but that's just because the city of Indy created it and put the fund together to put this together. But anyone in the state can go to this indyrenterhelp.org. This will generate a letter to be sent to the landlord, as well as a CDC tenant declaration that the tenant can save or put can save or or as a PDF and email it to their landlord, email it to the court, email it to you. This is just an easy way if the tenant can just auto-generate a CDC declaration, and it actually lets you use your your finger to sign it, so it's an actual signature. Also want to talk, but I know I've talked about this a bit in the beginning of it, is that Indiana Commission, or Chief Justice commissioned the Indiana Landlord Task Force last June, and that addressed all these issues, and you can see a copy of our report online about what we noticed at least about a year ago at this point. And then there are lots of resources available for both tenants, landlords, and courts. There's due process checklists for courts and suggested operations. There's Indiana has its own frequently asked questions document that was generated with lots of questions, frankly asked by the judiciary on what the extent of the CDC eviction moratorium is. So certainly check out the Supreme Court site to see all the forms on there. There's also sample repayment plan forms and things that tenants can use and have as a guide to start to try to negotiate with their landlords to work out payment agreements. So hopefully they can avoid eviction and get onto a path where they feel some housing security, knowing that they can pay off any debt they may owe. Probably already went through that. And finally, I'll just kind of end with this Landlord and Tenant Settlement Conference program. This is also something that the Landlord Tenant oh my goodness, the Landlord Tenant Task Force came up with. This is a free program. This is something that can be entered into either before or after an eviction case has been filed. I know it engages mediators who have been trained. I think some of the mediators come from the mortgage foreclosure program. I think some senior judges and retired, not retired, I shouldn't say that, but at least I think some senior judges also have volunteered to be part of the program. So this is a great way to get the parties to the table and have a third party really try to help balance the interests and find something that satisfies both parties, and hopefully get a soft landing for tenants. Again, either party can initiate it. Doesn't require a party case to be filed, but just know that both parties do have to agree to participate. So again, we try to reach out to landlords and encourage their participation because this is a great service, and we hope more people use it. And then there's just the balance, and there's the website for you. I think that does it for me. Please contact me if you have any questions, if I can help in any way, or if anything today didn't make sense. I know we're running on a tight schedule this morning, and my goodness, I can't believe I finished on time. So again, I'll leave that up, but we're gonna go on to a break now. I think we have about 10 minutes, and so plan to please come back here around 11:15. Thank you, everybody.
All right, everyone, we have a pretty packed program, so we're going to continue on now, and I will introduce Magistrate Kathleen Belzeski to give us some advocacy tips from the bench.
Good morning. My name is Kathleen Belzeski. I'm a magistrate in Lake County Superior Court. And I'm here this morning to give some advocacy tips for you. I don't have any slideshows. I don't have anything like that. I just have some information on how, at least in my court, we've been proceeding, and maybe some tips on how to handle now, because we've been continued with the moratorium, and to see how we can proceed forward, because there's going to be some more issues based on what happens once the moratorium is lifted. So anyway, I would like to thank the Indiana Bar Foundation for putting this together. I also would like to thank Supreme Court Justice Rush and the rest of the Supreme Court, because they've really, not only through the pandemic, but in other areas, have really taken steps forward to make sure that everybody has legal representation, and I appreciate that. I don't have a lot of time, so I'm just going to go right into it. Some of the things Brandon had already touched upon. One of those is, I'd like to start with, though, especially I know we have some young lawyers here. It is wonderful, everybody wants to volunteer, but one thing I would emphasize, know what the law is. Go and read the statutes. They're not long, they're not hard. Go during lunch. When you're eating lunch, go on to Lexis, look at the cases. Before you walk in, information, I once was told when I was a younger attorney, being prepared is probably, you're going to win 90 to 95 and by win, or at least prevail in 90% of your cases if you're the one that's prepared. And if you know and you prepare for your cases. So it's really important. I would go wherever your district is, look at the Lake County, look at your bar associations, look at the county court websites. Many of them have really good forms on them for other things, not just this type of area. So I would definitely go ahead and look at that. I mean, I've sold forms from other county websites when I was looking for one. Talk to the court staff and talk to the judges. As long as it's not a particular case, I have no issue taking calls when people want to know exactly what's the procedure or how things go in the court. So that's very important. Resources, and someone's going to cover that. Know the resources. I like to think, especially with what's going on now with the pandemic, almost like the criminal end where they have wraparound services. Know what's available for your clients, whether it's the counseling through 211, whether it's for electricity and things like that, water. There's other services out there or other places that will provide some kind of help or payment. There's a lot of them, just a lot of places. In our county, we have townships. The county itself has an economic development commission that was giving out money. So there's a lot of resources. So even in your jurisdiction, make sure you know what those are. So that's a couple of things. The other thing is, again, the bar associations have been wonderful. I know Allen County actually has a helpline 2 days a week that people can call and talk 3 to 5 minutes. So know the law and know what's available. I'm approaching this two ways. One is before court, what you want to deal with your clients, and what, or actually three ways. What you want to try to advocate for your clients in court, or at least what may or may not work in terms of arguments, and then what we're going to do moving forward. So before court, and Brandon hit the nail on the head, many people are not aware of the that the CDC moratorium or their rights under that. They'd come into court and I'd say to the landlord, did you receive a declaration form? And then I turn to the tenant and ask them the same, did you fill one out? Because most of the time the landlord didn't. They said, well, what is that? And it's interesting because we have it on our website. We have it in the, we have it posted in the clerk's office, but it's many places that the tenants aren't going to go. So they don't have that knowledge. So first of all, you need to make them aware of what their rights are before you go to court when the eviction's filed. The forms, help them fill out the forms. Set up places where they can get assistance. That has been the hardest thing, because even I would give time then. Okay, they weren't aware of it. I would go ahead and I would say, all right, we're going to give you 7 days. And I kept my docket active the whole time. Every judge is different. And that's the other thing. You're going to get different judges react to arguments differently. We have many different counties, and small claims, again, the rules of evidence don't apply, but we do have to apply the substantive law, and I'll talk about that a little bit later. But getting help with the forms, because even they come back a week later, well, it was rejected, and then you've got to find out the reason. So that was probably one of the biggest obstacles, is that people didn't know that they had this right to do this. Once we get through all that and you discuss that, you need to educate them too on what to expect. The biggest thing is tell people to show up, even if you're not going to represent them, if you're just giving them, side advice, or they don't qualify and you're just speaking to them, tell them to show up. It just works out so much better when we get both sides, or we find out what the real issues are, because it might be something that we can stop, that will stop the eviction. Tell them to talk to their landlord. They're afraid to. They're afraid what to do. And again, some landlords are not approachable. And I'll admit that. But you want to make sure that they will talk to their landlord to maybe try to work something out. Again, talk to them about what resources are available, because some people will be evicted. And in my court, again, I have a lot of landlords that are represented by attorneys. I have some self-represented landlords, but not, I have a good share, but not too many. And so you need to tell them to try to talk to the landlord. If the attorney is involved, try to talk to the attorney, but also let them know about the landlord tenant, about the settlement conference program. Again, I agree it's being underutilized. I think it will be hopefully more utilized as we move forward. And tell them what to do if they have to be. The reality that is that some people are not going to be able to stay. They don't qualify under the moratorium. There may be another legal basis, but set them up for reality so they know what to expect, or what could happen. Not that it's going to happen, but they need to know what the results might be. The other thing is, if they have to leave, tell them, take their pictures, make sure that they protect themselves when they leave the property. So those are all issues. Those are all things you want to do before you even get to court. Now, and it's interesting because now you're going to come to court. And again, it's hard. I'm giving some general guidelines here, or general arguments that have been made or could be made, because every judge, again, not everybody does the same thing. So you have to be aware of what's happening in your area. Now, and again, small claims, we're dispensing speedy justice during the pandemic. Unfortunately, it's not really been speedy due to the fact that we've had so many different orders coming down affecting different types of property. But again, substantive law does apply. I do think if you're representing litigants, you have to remember there's going to be a difference between dealing when you have an attorney on the other side who is representing, say, a big apartment complex, as opposed to somebody who has a home that they're renting out. So that's those are some issues that you want to make sure that you're prepared for. When you are representing them and the person's got served, look at the pleadings. Again, many times they're not attaching the contract. Sometimes it's on purpose, sometimes it's not. But the contract should be attached, and most of my cases have written contracts. So look at that contract and look at the notice provisions. And again, that is something that I'll discuss later in terms of some other issues. But see whether notice under the contract was properly given. Make sure that that they're not withholding the contract, and I'll get into that. And some landlords were. And then also look at whether or not there's been a property certification. And this is important because single family homes that are federally subsidized, and I think Brandon had touched upon that, they have to certify that it is not a covered property under the Act. And if you go to the Landlord Task Force, we do have those forms there. And I'm finding that many times these property status certifications were not filled out properly. Stopped a lot of evictions. Now, granted, the tenants don't know what to look for. I actively made sure that all the pleadings, but you never know whether or not there might be a judge who, oh, here's the certification. And it's a little check mark. It might be signed, but the box isn't checked. And many of times when I brought that up, oh, counsel, by the way, they're looking for a default eviction. I didn't see that you've checked that box. And, oh, okay, we'll get that back to you when we file the eviction. And I never got the eviction. Because again, one thing I would try to emphasize when I was asking about the property certification is that it is signed under the penalty of perjury, and there are penalties that would accompany that. And it's something that, in fact, I believe that as an advocate, you need to make sure that the proper type of information has been provided to the court. And it's interesting when we talk about the CDC form, I would give people time to fill it out. Ask the court for additional time if they were unaware of it. Now, recently it was through the Fair Debt Credit Reporting Act. I think that's where they said that that information has to be with the pleading, has to be provided directly to the tenants. Most of my landlords, knowing that I said I would ask at the beginning, actually really did provide that information. They started attaching it to the pleadings because they knew that, okay, here's another delay. They also knew that most people wouldn't fill it out. Now, and a lot of people didn't fill it out and didn't appear. And at that point, my hands are tied. But there were a lot of people who received it, tried to fill it out, didn't know how to fill out, but they'd appear and say, I want to fill this out. I don't know how. And then at that point, additional time be given. They'd be told what resources they may go to. So it really did help in the long run. Did my self-represented landlords, of course, didn't, nor depending on how big they were, weren't really required to. But I did always bring it up at every hearing. And I can tell you what's interesting is, in terms of talking about justice, this isn't having the CDC declaration form filled out really isn't, it's helping both parties. Because at this point, if they qualify under that, they're going to qualify for most of the aid that's been provided now. And a lot of the landlords were kicking and screaming. They didn't want to participate. The ones that did received money right away, first from India, and now Lake County has their own program. And that was a whole nother problem because it took about a month to get it going. But most of the landlords that cooperated from the beginning, they've been made whole. The ones that didn't realize that, wait a second, they probably got more money than they would have had all the evictions taken place, because many people, because of the pandemic, didn't have the resources to get caught up or to pay the back rent. So, again, informing both litigants, because it did benefit both parties, or it has benefited at least the way it's been working out in my court. But I did set a lot of statuses. I did to make sure that all documentation was done. I did have one landlord, and I wanted to bring this up, that didn't cooperate. So they would not give, they wouldn't give them the contract. They wouldn't participate. They'd be contacted by whatever organization. They didn't do that. I found that at that point, the party could not be evicted. If they would not participate, that's not a basis for them to say, well, they're not getting aid. And some of the landlords were trying that, and it didn't work, at least in my court. Again, I can't comment on everyone, but that is an argument, and I think a very valid one, that can be made by a tenant in court if, in fact, the landlord refused to cooperate. Again, that particular landlord changed their tune after they found out that really there was going to be money there. In terms of that also, when you have the hearings, I think when you're in front of the judge, ask that the issues regarding the late fees and other fees, after the end of July, ask that be determined at a separate hearing, or if eventually there's going to be a damage hearing, at the damage hearing. I find people are much more civil when we're just talking about the rent and how they can be made whole that way. And frankly, a lot of these contracts do, I think, have penalty provisions, as opposed to true late fees related to what they really will experience in loss if the rent is late. So those are all areas that you want to bring up. And I do have a lot of times where we will be hearing the late fees, but it might be something you want to advocate for early. let's talk about the real issue here, and we can deal with the other ones. Because a lot of these people are good tenants and have been good tenants, but for the pandemic. So that is one thing that you really want to advocate. Also make sure that it's interesting because the CDC, and Brandon brought up other reasons you can be evicted, only addresses rent. And I'm getting a lot of cases now where the lease has expired. And that's a little dicier. So how do you argue that when someone comes in and says, hey, the lease is expired? This isn't a rent issue. Though rent is past due. Some are not, but some are, or the house has been sold now and the lease is expired because of the housing boom. So that's a little different situation. And I mentioned looking at contracts because many contracts do give notice provisions. 30 days notice, 20 days notice, whatever it is. Most landlords did not comply with that. So that gives time for either to say, hey, I do not believe you qualify, because again, remember, we're under substantive law and judges are going to interpret things different, but those are contract rights. And a court is very leery and really probably shouldn't. Once a contract expires, what rights do they have on it to, or alter the contract and saying, well, no, we're going to extend it. So that is, what is your argument there? One, I think you need to look to the notice provisions because that will buy some additional time. And two, argue that the CDC is unclear. You can argue what the intent is. You can argue that it didn't really specifically exclude when the contract expires, especially if there's been no payment of rent. But I guess you would just argue that it's unclear and should still be covered by the CDC. So that's been an issue, and it was not covered under the frequently asked questions. So you have to talk about contract. Well, again, they're going to probably argue their contract rights, but argue it's not clear that the intent of the CDC moratorium declaration was to protect these people. So these tenants. So that's one thing you want to do. We discussed waste earlier, and that's another interesting one because at the beginning, and again, this goes to the attorneys not even reading what the statute says, filing, trying to get emergency hearings because of waste, alleging non-payment of rent, which doesn't qualify under the emergency statute. So that's real interesting. And those statutes, again, are 32, 31, 6, 3, and 4. And there has to be some kind of injury, loss, or damage alleged. I know there was a question about that, and it was interesting because the question was kind of phrased like when it's in front of the court and it's not specifically alleged. Now, I did find out in some jurisdictions, I was finding out that the clerk's office was setting these for the judge. Technically, the judge reviews that. None of those get set until I review it and see. If it's not sufficient, it gets rejected. If it is sufficient, and I think I only found 2 during this entire time, and one dealt with violence, extremely violent situation. And so the judge has to review it. And yes, it should be pled. If it's not pled, as an attorney representing a tenant, you have a very, very good argument, at least to buy time. If in fact there is a situation where it comes, because we have notice pleading, if there is a situation that comes where it really does seem that the allegations are serious enough that it should be an emergency hearing, at least ask for 2 or 3 days to be able to review whatever evidence that should have been pled or should have been shown in the complaint. So that way you at least can present a reasonable defense to that and ask that it be continued 3 to 7 days out. So that is something, again, as a representing the tenant, that you can do. Eviction expungements, we don't have that in Indiana. There's no such creature. Someone asked about that. There are ways that you can try to keep evictions off the record. One thing I would do is, and I've done all along, is I would say, okay, especially for those that don't qualify and need to move out, will you voluntarily vacate by such and such a day? And again, it's important that you know your client and have the facts. The reason being is that if you make that, if I have someone who's been there 20 years, I'm going to give them, whether they're behind in rent, more than 2 days to get their things out. Again, everybody's had really horrible situations going on. I'm not saying I'm giving them months and months, but if you say, would you voluntarily vacate by such and such a date, we will not issue an eviction order. However, if you don't, on motion, verified motion, if you're not out, we'll issue that eviction order. That's been quite effective in keeping evictions. Again, the eviction's been filed. Some of my landlords will dismiss it after the damage hearing, or if they're not seeking damages, I should say, they'll dismiss it. So it's been dismissed. One other thing is, and I've had people ask, and I'll set them for hearing, that the eviction order be set aside. And some people say, well, why would you set that for hearing? Perfect example. I had one the other day. The woman was already out of the property. And I think the landlord knew that, but still came in and got the eviction order. And so some people will just ask, and some landlords who are nicer will say, I don't care, you can vacate it. I have another one who says, no, they've destroyed the premises, I'm not going to do it. So again, we have to weigh the equities and look at the facts of the situation. One thing I will do, if in an order, if they agree to set it aside, or if I order it set aside, I will put in there, so it doesn't reflect on them for future housing, that in fact they had vacated the property. So that is something that I will do. I will make more specific findings in the order as opposed to just setting aside the actual eviction order. Damage hearings, those are, moving forward, that is going to be more of an issue. However, I think most of my tenants, most of my landlords, who everybody's pretty much been very cooperative, are getting paid. Even my self-representative litigants that just didn't understand the process. But we have the late fees, we have those that just sold their property, we're going to have damage hearings. I think that's when we want to bring in the landlord and tenant settlement conference program. And I think as an advocate, if you're in court and suggest that, because I think they'll feel they have more, both parties, more control over the process as opposed to letting the judge decide it. And again, we get into the late fees, that type of thing. I think that's going to be more of an issue going forward. So those are all things you want to make sure that you do. Generally, evictions weren't continued in the past, and I don't think in the future, once we get back to, we're still at a new normal, I don't know that some of these arguments will work, but it is important that at least for ones that are covered under the Act, asking for time, checking the forms, being aware of what the law is, being aware of what the changes are is very important. This has been a difficult time for, and it's interesting because it's been a difficult time for, the landlords, the, judges, the lawyers handling all these cases. But imagine you're the tenant. Again, that's a whole nother thing. It's been very, very difficult. And even when you're talking about resources, I think you need to talk about mental health, looking toward the future. There's a couple things, and here's a forum where we have it with attorneys and advocates trying to get some information. I would suggest perhaps doing some community forums about what your rights are, about the fact that a tenant can actually file in court when there's an issue, that they have rights that can be asserted, that I would also, to know what assistance is available out there, even not during a pandemic, because it's there. I know we have townships in Lake County, they've always had assistance. It might only be for a month or two. I think our county council offers $1,500, and this was all pre-pandemic. So know what resources are there, even when we don't have this kind of crunch. The other thing is I would, and I think Brandon touched on this, was our landlord tenant laws. One thing, when you look at our contracts, many states have notice provisions in there, and it's mind boggling to me. And I know this because they have children that have been out of state in this, but the contracts are so different than what I encounter in our state. And they will say the landlord has an obligation to give notice that the tenant has to give notice, and vice versa. I would like to see something. I think it protects both the landlord and the tenant, because then you know what's going to go on. So I would say that, you know, I would like people to advocate that. The other thing is there's got to be communication, I think, between the bar, between the courts, between the community, even our sheriff's civil office. During this whole time, I know the attorneys were communicating. The sheriff would come, okay, we just heard, how does that affect us? It takes everybody to make sure that things move forward the right way. And I can tell you, the benefit for this and the landlords, and I stress this, you know, it keeps the property value stable, it keeps the community stable, it keeps children in their homes. So to me, it's very important that we work with both groups, and even with the landlord tenant task force, all these things were taken into consideration. So it's very important that we do that. Justice Rush mentioned the book Evicted. I think it's from 2016. I think it was Matthew Desmond. She mentioned that book a few years ago, and I read it, and it really is a good read, and it makes you think. It puts a different perspective on things. So again, education, you know, forms, just trying to get the resources to the people who need it most, because I found that a lot of people did not know what their rights were. I think that's really what we need to do. At least people need to do if they're advocates, and moving forward. And I think I covered everything I wanted to. I had only had a half hour. I'm 3 minutes short. I had a lot of information I wanted to get in. So that's what I have to say about moving forward with the courts. But please, I hope people take advantage of the resources that are available, especially that landlord tenant settlement conference, because I think that with all the damage hearings coming up, that if you suggest that might be used more than people know. So thank you so much, and thanks for having me.
Wow, thank you so much, Magistrate Belzeski. That was really informative and helpful. So thanks for your time this morning. Now we're going to transition on to Jennifer Phillips, who I must give a special shout out to, who is joining us last minute. We had an emergency that occurred, so we thank you, Jennifer, for joining. Who's from IHCDA and going to talk about the statewide rental assistance program. So Jennifer, thank you.
Thanks, Brandon. Hello, everyone. I'm going to share my screen really quickly here. So, as Brandon said, I am the attorney with the Emergency Rental Assistance Program with Indiana Housing and Community Development Authority. And I'm going to give an overview of our program, which might be a helpful resource for some tenants as they're facing eviction or not being able to pay their rent. I do have quite a few slides with a lot of information, so I'll try to get through them all quickly. There may be some that I skim over or skip over. For an overview of the presentation, there's a few disclaimers about the program. I'll go over the federal authorization and guidance over the program and talk about which households are eligible, the types of assistance we offer, and then an overview of the application process. So first of all, I think it was already mentioned earlier that our program covers most of the state of Indiana, but there are certain parts we don't cover because some local areas have their own programs. So if you have a tenant living in one of these other areas, they'll have to go through the local program. That's the city of Fort Wayne, Elkhart County, Hamilton County, Lake County, Marion County, and St. Joseph County. Second, this program is different from our previous COVID-19 rental assistance fund. There has been some confusion with that. We use the same online system, but it has different federal requirements, different state requirements. Someone who received RAF assistance can still get ERA assistance. We just can't provide assistance for the same months where RAF assistance has been provided. This is also about ERA 1 and not ERA 2, which is a second very similar program that's gotten federal funding and guidance. So this is only ERA 1 right now. So $25 billion was authorized for emergency rental assistance across the country in December 2020. The program is overseen by the U.S. Department of Treasury, and they've released several versions of FAQ guidance on the program. The most recent guidance was issued yesterday. So eligible households, they have to be renting and have a current rental lease obligation. There are three major criteria that we look at for eligibility. One is that the household's been impacted by COVID-19. Two, that the household is at risk of housing instability or homelessness. And three, that the household income is at or below 80% of the area median income. We don't have a citizenship requirement for the program. We do require them to provide some kind of ID, and we'll accept various different types of ID for that requirement. So the first criteria, impacted by COVID-19, if they meet one of these three things, they'll meet this qualification, and they only have to self-attest to these when they fill out the application. So if they've received unemployment benefits since April 1st, 2020, if they've experienced a reduction in household income on or after April 1st, 2020, or if they've incurred significant costs or experienced a financial hardship due to COVID-19 since April 2020, they could also be eligible. So that would be things like reduced income or increased costs because they've had to stay home or had medical costs associated with COVID-19. Test number two, so for a risk of homelessness or housing instability, they have to show option one is proof of arrears, so past due rent, past due utilities, or some kind of termination like a utility disconnect, notice to vacate, anything indicating an eviction. That's the first option that we prefer. Second would be we can calculate whether they have a housing cost burden, and that is if they pay 30% or more of their total household income as rent. We do sometimes have to collect additional income documentation from them to calculate that accurately. And then thirdly, if they don't fall under option one or option two, if they happen to be doubling or tripling up with another household, you know, living with friends or family because they can't afford their own place, they could potentially qualify because of that as well. So number three is the income qualification. Again, that is if they are at or below 80% of the area median income. If they have a determination letter that says they qualify for certain assistance programs, we will accept that and won't need to collect any income documentation. So those programs are SSI, TANF, SNAP or food stamps, HIP, WIC, and recently added, Treasury said we can also use housing choice vouchers or public housing as proof. If they don't have any of those documents, we will get either a 2020 1040 tax return from them, or we will get 2 months of income prior to their application to calculate. And that second method is based on Housing and Urban Development's annual household income, which is used for other housing programs as well. We usually require them to actually submit documents instead of just self-attesting. There might be certain circumstances where we allow a self-certification, but generally they'll have to submit some things like pay stubs or unemployment payments or something like that. And this is just a chart showing the income amounts. That second one, the 50% AMI, that actually comes into play with our priority eligibility. We have to prioritize certain households. So those can be households where the income is at or below 50% AMI, as well as households where someone in the household has been unemployed for 90 days prior to application. And a note on landlord participation for this program, it's also a little different than the previous rental assistance program. Landlords don't have to participate in the program. If a landlord decides not to participate, the tenant can still receive assistance. We do have to try to work with the landlord initially. We will try to reach out. But if the landlord does not want to participate, or if they don't respond, we can issue the payment directly. We'll send a paper check payable to both the tenant and the landlord if that route is followed. So a couple of questions we've gotten about whether certain households can be eligible. First, if they're receiving vouchers, yes, they can still get some assistance. We'll cover the tenant paid portion of their rent, as well as any utility arrears under the program. We just can't duplicate what's paid through the federal subsidy. So that applies for housing choice voucher, public housing, as well as project-based rental assistance. We will also accept rent-to-own agreements. There are a few requirements with that, but generally, if they're still in the rental phase of the agreement and they haven't yet purchased the property, they can still qualify under our program. And finally, mobile home renters, they also qualify for the program as long as they're renting their mobile home or the lot or both, they can qualify for it. So the program allows for up to 12 months maximum of assistance. Rent includes arrears back to April 1st, 2020 or after, as well as forward-facing rent approved in 3-month intervals. Every 3 months, a tenant has to recertify to continue receiving the forward-facing rent. Rent is capped at the fair market rental, which there's a chart on here that I will just skim over. We also provide utility arrears coverage for arrears only. We provide internet arrears in certain circumstances, and we will also cover reasonable late fees that were incurred. So really quickly through the general process, so you can see some of the steps. Initially, intake staff work to make sure that all the program requirements are met, and this is the document collection phase with the tenant. We might decline an application if someone has not responded or provided information, but we can usually reopen it later if the tenant starts responding. After someone's been deemed eligible, we contact the landlords and utility providers, and we will do that through an online submittable account, which is the online system that we use. So landlords just need to be sure they're checking their emails if they know that residents have applied. Once we get information from landlords and utilities, we then determine the exact amount of benefit that the household can receive. And then once we've determined that, we will process it for payment and issue a payment. Landlords can choose to get payment by direct deposit or paper check. So depending on which one they choose, that can affect the time frame that they get paid in. And then just a note on what tenants get from us so that they can sort of know where their application's at. They'll get an email that their application was submitted, and then they'll get an email later on that says they were found to be eligible with the threshold criteria. And then third is sort of this general, yes, you've been found eligible to get a benefit. Some tenants have given that email to their landlords, and the landlords have found that email, helpful in them deciding to keep the tenant housed a little longer because they're thinking they're going to get the assistance soon. And we do not contact vendors, so landlords or utility providers, until a household's reached that third step where we've approved them for eligibility. So this is our general contact information. There's instructions for where tenants can go to apply. We also have our hotline, which is the 800-6000 number, and our general email about the program if there are specific questions. And I'll probably end up giving you my contact info as well as our director of the program, Rihanna Binder, who unfortunately couldn't be here with us today, but she also is great with answering program questions that you might have. And I think I am about at time, and I think that is all that I have.
Thank you so much, Jennifer. And again, thanks for stepping in for that great information about the statewide rental assistance program. And our final speaker today is the Executive Director of Pro Bono Indiana, Scott Wiley.
Well, thanks so much for everybody who's participated today. On behalf of all of us that have been putting this together, the Coalition for Court Access, Indiana Bar Foundation, Marilyn Smith's wonderful work, and all of our speakers today, we're very appreciative of everyone listening to all this information. This will, of course, be on demand as well for those of you who are watching later after we have done this live version. And the information that we have given you in terms of all the data and other things will be going out in emails and Dropbox and other ways that you'll be able to access all of the information that we've gone over today. I just wanted to start real quick before I did. The Chief Justice had a message that she forgot to give and update everyone on our Court of Appeals Judge Vedic. Just wanted to let you know, some of you may know that she had a pretty terrible accident, but the Chief Justice wanted everybody to know that she's healing and she's in a rehab facility now. The Chief Justice is speaking with her frequently, and her spirits are great, and she's working hard in rehab. She's got several broken bones, had to have a surgery already, but is healing. So just a few things to finish us up today. First of all, for each and every one of you who is on the call today, regardless of whether you're a law student, a paraprofessional, or an attorney, there is a way you can help in this crisis. Our communities have been very burdened by COVID-19 and the housing crises that has caused. Do not think you cannot do it. One of the questions we had posed to us when we were presenting this is whether real estate attorneys, how they might deal with conflict issues. I just encourage you, we're going to show you how to get in contact with your local pro bono professional in your area so that you can volunteer. There are lots of opportunities to do court-based and other clinical work. So if you are a real estate professional and you're concerned about conflicts of interest, Rule 6.5 of Rules of Professional Conduct allow for you to participate in those clinics without doing additional conflict checking, and you don't take conflicts back to the office with you. So please review Rule 6.5 if you have a concern about that, but it can be addressed, and there's a role for each and every one of us as we go forward. And thanks so much for those of you who will be volunteering. The next couple of slides, I'm going to ask Joseph just to go ahead and scroll through. We've got a few slides. What you're going to see are there eviction assistance opportunities throughout the state. I want to give a couple of shout outs. Indiana Free Legal Answers. It's an American Bar Association platform. That platform can be reached at that link you see. You can register there and answer simple questions. It's a wonderful way to do pro bono work at your time, at any time. I answered a question this morning when we were all getting on. The reality is a lot of the questions coming in involve pandemic issues like what we talked about today. So please consider going to that link and registering to be a volunteer. It doesn't require you or obligate you to do anything, but you can review questions that are posted by Hoosiers who need legal help. And Dana just put a note in the in the chat box as well about the website, which is probonoindiana.org, where all this stuff will be placed as well. You'll also see that there are brief advice clinics that Indiana Legal Services doing. And then as Joseph scrolls through the next couple, you'll see that in each of our major cities, our local pro bono program either has a contact person and or various programs that you can look at as opportunities so that you can email or call your local pro bono office managing attorney or manager, and they will help get you hooked up. And that's not just with Pro Bono Indiana's various programs through the state, but also our friends at Indiana Legal Services, Neighborhood Christian Legal Clinic, the Legal Aid Societies in Lafayette, Evansville, Indianapolis, South Bend. Will be able to hook you up in a way that will be meaningful to clients. And this will be available on Pro Bono Indiana's website. It'll be in the link and the material that come to you following this training, which will be out as soon as we can possibly get it done. We'll have a Dropbox link to the session materials that will be emailed to you after this session. We'll be putting the CLE link and password in the chat. So if you are looking for CLE credit for this session, be sure that you access that before you hop off the call. And the Indiana State Bar Association, which hosted us today and really helped in coordinating this along with Marilyn Smith, will host on-demand recording of this training in its library, and that will be available after July 2nd. So the CLE link is now in the chat box, so be sure you capture that before we finish up. Just to close our session today, one of the things that we've been dealing with for the last 15 months is how this pandemic has changed how services are provided. There are lots of ways that you can help people. As the pandemic comes to a close, hopefully, and this eviction crisis reaches its day of reckoning, which we think will now be July 31st. But when it finally does reach its day of reckoning, we'll have a lot of unresolved evictions that are still out there, like Brandon talked about. One of the main concerns we all have is that people who have moved to different housing and have left and self-resolved in any number of ways may not get notice or know about returning for rent and damages hearings or other such things. We don't want default judgments for $8,000 or $10,000 against individuals who only owe $1,200. So do your best to volunteer for these programs. Help us get the word out that people need to pay attention and return for their appropriate eviction and rent and damages hearings. And don't think that your work that may not stop someone from getting evicted, but may give someone the ability to have less damage doesn't matter. So with that, I'll turn it back over, and I think we're finished today. I hope everybody has a wonderful rest of your time. Brandon, if you want to close anything out, feel free.
Thank you, Scott. I just want to say thank you, everyone, for attending today and your interest in this topic and hopefully willingly to go into the courts and help tenants and resolve these issues. I want to give a special thanks to all our speakers today, Chief Justice Rush, Jennifer Phillips, Magistrate Kathleen Belzeski, as well as Scott Wiley, and also to Marilyn Smith, who made this super easy to do with all the logistics. So thank you, everyone, and thanks for coming today. And feel free to reach out if you have any questions or want to continue to see how you can implement this into your communities. So thanks, everyone.